Very much, Your Honor.
Court calls the case People versus Larzell, Washington.
Good morning, Edward Gibbs on behalf of Larzell, Washington.
This case opens with chaos, confusion, and plenty of drama. Judge Simpson presides over a courtroom where defendants push boundaries and test patience at every turn. Today, we'll see everything from heartfelt pleas to outright clashes between a frustrated defendant and a judge determined to maintain order. Right from the jump, we're introduced to Washington, a man whose case is tangled in delays, recovery court referrals, and missed hearings. But what makes this so gripping isn't just the paperwork, it's Washington's raw emotion and bold attempts to sway the court. Notice how he interrupts, explains, and even challenges the process itself. This isn't routine court business. It's a verbal chess match where credibility, composure, and control are constantly on trial. And as we progress, keep your eye on Judge Simpson's calm but firm handling. Will patience hold or will tempers erupt? Stick around. This is going to be unforgettable.
How you doing, Your Honor?
I'm doing great. What's your name?
Larzell in Washington.
Thank you.
Thank you, sir.
Your Honor, we had referred this over to the recovery court. I spoke with them and they indicated that they've in receipt of all the information to do an intake. However, they have not done that interview. That interview could be completed within a week. Like if we could have a 1-week adjournment.
Here we already
Probable
see an
cause
important
conference,
moment
May
of courtroom
22nd,
mechanics.
2025.
A probable
9
cause
a.m. bound
conference is
continued.
not just a formality. It's the stage where attorneys can negotiate, resolve issues, and possibly strike deals before the case heads into a preliminary examination or trial. Judge Simpson sets this date firmly, signaling that deadlines matter here. But look at Washington's demeanor. Instead of simply acknowledging the date, he pivots into a personal appeal, asking to address bond and airing frustrations about missed hearings and miscommunications. This highlights a common courtroom tension. Defendants often feel trapped by processes they don't fully understand. Washington's insistence shows both desperation and strategy. He's trying to take control in a space where the judge controls everything. Question for you: if you were in Washington's shoes, would you speak up like this or stay silent and let your attorney handle it? Think carefully. Your words in court can shift outcomes dramatically.
Court calls case People
Excuse me.
versus Marquise
No,
Fab.
oh, excuse me, sir.
Yeah,
Can I please have a word? With all due respect.
I think Mr. Washington would like to address bond.
Excuse me, miss.
go ahead.
How you doing, Your Honor? My
I'm
name is
great.
Larzell near Washington. First and foremost, forgive me about my outbreak last time I was here.
Can I have that file?
And thank
Go
you,
ahead.
sir. Thank you, sir. What happened was, I wasn't aware, as my attorney indicated, what day was my probable cause hearing was. Okay, I went back to the magistrate. They said, no, well, we're gonna let Judge Simpson handle it. Then last time I came here, it was a 2-week hold because they didn't do their job. I feel I shouldn't have to
They
be.
didn't, who didn't do the job?
What you say? You gave him a plea.
The recovery court?
Well, I didn't ask for no recovery court, but whatever assessment you gave him, it was 2 weeks. And the honorable judge said, okay, well, I'm not going to change his bond. Now, you still didn't indicate I was looking for a bond. And I wasn't even aware of a drug court. So with all due respect, I do appreciate you, but I did, unfortunately, miss my court date.
Right.
I was,
And then how'd you come into custody?
oh, I came into custody? What, trying to, being a good Samaritan. Some woman was being stalked and they figured out what my name was, and I totally forgot. I really didn't know what court date it was.
This explanation is jaw-dropping. Washington claims he missed his court date not out of defiance, but because he was being a good Samaritan during an unrelated incident. This defense does two things. It humanizes him, showing a man who intervened to help someone, but it also raises credibility questions. Judges hear every excuse imaginable, from car trouble to mistaken calendars, but linking a missed appearance to a heroic act, that's bold. Legally, it doesn't change much. Missing court is still missing court, but psychologically, Washington is trying to frame himself as misunderstood, not irresponsible. Notice Judge Simpson's careful pushback, asking who is they. He's poking holes in the story, signaling skepticism. This is courtroom theater, one side spinning narrative, the other dissecting it.
And I was disciplined for the first, and in discipline, well, not necessarily discipline. You allowed it to, override until they took care of their situation, but it's not my fault.
So they who is they?
Would you explain to him?
Well, I think I got to collect more of that story.
Okay, you gave him a piece of paper about assessment along with a plea.
Mhm.
Okay, I get here today, the assessment is not taken care of. Right?
You just want them to speed up the process.
No,
I think we
not
gotta-
them. It's not his fault. He's a judge.
Mhm.
They
Thank you.
supposed to be.
Thank you. Thank you. Thank you. Thank you. That's right. Nothing is my fault.
No, yes, it's not.
That's right. I know.
Amen.
Washington latches onto the judge's words like a lifeline. Nothing is my fault. He repeats it almost as if he's been vindicated. But this is a classic example of selective hearing in court. Judges often use ironic phrasing or momentary agreements to move a conversation along, not to absolve responsibility. Washington interprets it as validation. This shows us how fragile the communication between judge and defendant can be. One side speaks from authority, the other hears what he wants to hear. Washington then emphasizes his carnival work and his discipline, trying to show he's reliable and hardworking. But in legal proceedings, reliability isn't proved by words, it's proved by showing up. This tension between self-perception and legal reality is striking. Do you think repeating the judge's words strengthened Washington's case, or did it just make him look desperate for validation?
So I'm saying, I'm just trying to live my life. I normally work the carnival shows. I have really been disciplined for not being aware of to show up. I'm not dumb enough not to show up again.
Excuse me one moment. Whose phone is that? It's somebody down there's phone. Is hers? Tana's phone? Really? Go ahead, sir.
And I'm not ignorant enough not to show up in front of Judge Simpson courtroom again.
I think he is saying that he would show up to court next time. He's asking for a PR bond.
Yes, I am, sir.
If the court would not provide a PR bond at this time, if the court would allow an interview to take place, if that interview takes place, then the court.
Here Washington makes his most direct request, a personal recognizance PR bond. For those unfamiliar, this type of bond means you're released without having to pay money up front. Essentially, the court trusts you to return. Washington's plea is heartfelt, but there's a problem. His track record already shows missed dates and inconsistencies. PR bonds are given when the judge believes you're reliable. His past absence undermines that. His attorney tries to soften the request by suggesting an interview first, but Washington pushes back saying, "I never said that." This clash between defendant and attorney is dangerous. Judges don't like confusion in bond requests. It looks disorganized. If you were Judge Simpson, would you take the risk of granting a PR bond here, or stick with the safer option of keeping him detained until trust is proven?
Provide a PR bond.
I never said that. I asked, could you please provide a PR bond? And I will.
I addressed this the last time you were here.
What was it about?
I think they're gonna keep you in.
All right, man, you're fired. God bless you. And thank you, Your Honor.
Why is he fired?
Because he's not speaking up for me. I really don't even know what's going on.
Oh, it would, okay, so did you understand before you make that final decision about firing him? It
Well,
wouldn't have mattered whether you spoke or he spoke. I was denying your motion. I've already
okay.
heard it.
I don't know.
This is the turning point. Washington fires his attorney in frustration, accusing him of not speaking up. But here's the reality. Whether the lawyer argued or not, Judge Simpson had already made his decision. This illustrates a harsh truth about courtroom dynamics. Defendants often blame their attorneys for unfavorable rulings, but the real obstacle is the judge's assessment of credibility and facts. Simpson clearly states that nothing the lawyer said would have changed the outcome. That's a sobering reminder of how little control defendants sometimes have once patterns of missed court dates and inconsistent stories pile up. Washington's dramatic "you're fired" adds spectacle but no substance. Instead of swaying the court, it shows instability.
Why are you denying the motion? And what's so funny?
Because,
Wow.
because you appeared here, didn't show up, didn't turn yourself in, got picked up, got brought here.
Yes.
That's how we got you back.
And the
So I'm
magistrate,
not releasing you
right, the
now.
magistrate
Okay, so
did not release me, and then
that's right.
you didn't release me
That's
because
right.
you wait for assessment. Am I
And I
correct?
haven't had the assessment yet. Have I?
Exactly. So is it my fault you haven't had assessment? Is it your fault?
It's my fault? I thought nothing was my fault.
So whose fault is it?
I don't know.
This exchange borders on comedy, but it's also a tragic reflection of miscommunication. Washington tries to twist the judge's words back on him, essentially arguing in circles. If it's not my fault, why am I being punished? But the judge stays firm, pointing out that the assessment simply hasn't happened yet, and that's not on him. Here we see Washington trying to win a philosophical argument instead of a legal one. Judges don't debate logic puzzles. They deal in facts, missed hearings, incomplete assessments, and bond risks. The courtroom audience hears tension, but the legal bottom line remains unchanged. Simpson's refusal to play into the back and forth demonstrates judicial discipline. Do you think Washington's rhetorical tactic of flipping the judge's words was clever, or just proof he was losing grip on the actual legal issues?
But it's not mine. You do agree.
No, I don't agree.
The assessment, do I?
I don't know whose fault it is. It hasn't happened. I'm done.
Pretty much. God bless you.
Thank you, Your
And
Honor.
you.
Thank you, Your Honor.
Well, keep talking. Why are you up here at my, why are you at my podium? Why are you at my podium?
This is where courtroom etiquette comes crashing down. Approaching the judge's podium without permission is a massive breach of decorum. It signals defiance, boundary pushing, and a lack of understanding about hierarchy in court. Judges command space, and their podium is symbolic of authority. By stepping into that space uninvited, Washington turns an already tense situation into a confrontation. Simpson's reaction is sharp. "Why are you at my podium?" It's a reminder that physical boundaries in court are as important as verbal ones. Washington's actions could easily escalate into contempt charges if unchecked. For viewers, it's a lesson in courtroom discipline. Small gestures can carry big consequences. If you were watching this live, would you see Washington's move as bold resistance against authority, or as reckless behavior that only damages his standing further?
Next time, Tana, turn your phone up louder when that's going on.
And then it was.
Did I call your case?
Yes, you did. You called, Houston's Bath, Marquis Bath.
Oh, that was so long ago. You're right. You are right, Miss Cannon. And I usually criticize you for not getting up here on time. And I have to give you credit that you're like early.
Got it, Judge.
Court calls the case, people of the state of Michigan versus Babb.
After the storm with Washington, notice how the courtroom pivots back to routine. Judge Simpson shifts gears into the next case with almost mechanical calm. This contrast is powerful. It shows how the system itself doesn't pause for drama. It moves forward. For defendants like Washington, the emotional outburst felt like the center of the universe. But for the court, it was just one case among many. This dissonance is what makes courtroom footage so fascinating. Personal stakes are sky high, but the machinery of justice keeps grinding forward. Simpson's tone is brisk, signaling that his patience is intact and his focus is already on the next defendant.
As
Defendant on behalf of the people, Your Honor.
Stephanie Can on behalf of Mr. Beck, who should be appearing by Zoom. Oh, thank God. He's there.
Mr. Bab?
Please be there. So what had happened?
Marquise Bab, you need to unmute and turn on your camera. Every week, Cannon,
I
every week.
was doing my part today. Your Honor, we're
This
just
is
setting
gonna be
it for a
just one of
preliminary
those
exam.
days. What?
We're simply setting it for the preliminary exam.
I gotta have him, I don't know who, I gotta have him here. Oh, you're just gonna call him?
Yep. Yep.
Never mind. I'm gonna say something. This is practicing law by janaza. That's what you're doing right now. Court calls case of the people versus Kennedy Braddock.
David I. Goldstein appearing on behalf of the defendant.
All right, thank you.
That wasn't me
I know.
this time.
This time. All right.
Your Honor, we've executed a waiver form. We're going to be waiving exam seeking resolution in circuit court.
Is that correct, ma'am?
Yeah.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yeah.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of information in this matter. My client waives further reading, stands mute, asks that a not guilty plea be entered.
Defendant having waived former reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 9th at 1:30 p.m. with Judge Conlon.
July 9th, 2025, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue. Court does call the case of the people versus Anthony Flanagan.
Joseph and Gollum at the people.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Anthony Flanagan.
Thank you. What are we doing?
Your Honor, as the court is well aware, there was a competency evaluation done in this matter. We are now going to be asking for an evaluation on criminal responsibility, but we'll do that in circuit court. So we're going to waive exam.
Okay. All right. Is that correct, sir, that you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
All right. You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
People also waive their right?
We do, Your Honor.
7, 6.
Your Honor, we acknowledge.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 through 5 with 6 following. Go ahead, Mr. Wilson.
Your Honor, we acknowledge receipt of the information in this matter. We waive its further reading. My client stands mute, asks that a not guilty plea be entered.
Defendant having waived formal reading, standing mute to all 6 counts, court will enter a not guilty plea. Pre-trial will be set for
June 3rd at 1:30 p.m. with Judge Conlon.
June 3rd, 2025, 1:30, Judge Conlon.
You're all set.
Bond continued. Thank you. Court does call the case, people versus Corey Craig.
Come. come in. Okay, I thought he was out in the hallway.
Alexander,
David I. Goldstein, hearing on behalf of the defendant.
Your name, sir? Or good. All right. What are we doing?
Your Honor, I was prepared to ask the court for an exam date, but I was informed this morning when I got here that there may be some media that has not been provided as of yet.
and that's correct, Your Honor. I did put in a request for media discovery yesterday as well for the 911 call and have not received that. Thank you.
All right. And we're saying would you be available on 29th?
Oh, I'm looking at the 27th for some reason. Yes, Your Honor.
All right. Probable cause conference will be adjourned May 29th, 2025, 9 a.m. Bond will continue.
Thank you.
Oh, boy.
Good morning, Your Honor. Great to see you. Christina Costantino appearing with and on behalf of Haley Gregg.
See, you're over there. Your name is?
Haley Gregg.
Judge, this is a date and time set for a PCC, and we have reached a resolution in this matter. I do have a plea agreement if I could present that to the court. Thank you.
Okay, so how am I going to accomplish this?
Do you mean because it's a no contest plea?
Yeah.
Or
And I don't have a report.
I do have a clean copy of the report if I could also present that to the
So
court.
I'm supposed to read that now.
I know, Judge, I apologize.
Okay, the plea agreement indicates that she's going to be pleading no contest to the charge. The maximum penalties on here either.
That would be my fault.
Judge, if I could, the maximum possible penalty is 1 year.
Maximum fine.
Here we dive into legal arithmetic. Penalties, reductions, and first offense considerations often sound like a math lesson, but they are crucial. Judge Simpson carefully breaks down the numbers. 1,500 maximum cut in half for attempt, potentially 750. Notice the attorneys fumbling slightly, apologizing for lack of preparation. This creates a contrast. While the defendant's future hangs on every calculation, the lawyers are scrambling to get their math straight. Simpson's irritation is evident, though he remains composed. This moment highlights the complexity of sentencing law. Small details can make big differences in punishment. For viewers, it's a reminder. Courtroom outcomes often hinge on technicalities, not just dramatic speeches. Does this kind of legal number crunching make you feel confident in the fairness of the system, or concerned that too much relies on complicated statutes most people don't fully understand?
That one's a good question, Judge.
It's $4,000.
That it was. $1,000 on the attempt.
I believe it should be 500.
Yep, we're rolling along in that.
Sorry, Judge, I had to come along
Pushing home, and
and mess
I would
everything
blame
up.
both of them all day for this.
So
Not you.
sorry.
You're good. This is not your fault at all.
No, it's not.
I am looking at the attorneys that don't seem to be ready.
Very sorry, Judge, very sorry.
What's the maximum? Well, hang on, folks. The maximum penalty on this is going to be. Well. Give me the max on unlawful use and just cut it in half.
My understanding, the max on unlawful use is 1,500.
It's
However,
1,500.
It says if the case is a first offense, the court may reduce the punishment for imprisonment or the fine of not more than $500. So the maximum would be 1,500. The court could, of course. do
On the
more.
principal charge, it would be
Yes.
1,500, which means on this attempt, it's 750.
That would be
All right.
my understanding. My math is not great, but it seems right.
Is she signed an advice of rights? Well,
Goodness. Judge, I'm sorry.
but let's see. We called one case of Constantino's and I could have done like 8 cases.
I know, Judge, I'm so sorry.
No, it's okay.
You decide here.
I
It's
have
hard to get the
I have no
signature when they're in
waiting.
custody.
problem waiting. I don't think the rest of these people have that same feeling.
I understand. I apologize to all of my colleagues. Need you to sign this as well.
I'm so nervous.
I need you to sign there. Sign.
I don't- Okay. All right. Are we finally ready?
I think so, Judge.
Yeah, let's see. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Haley Gregg.
All right. Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of attempted unlawful use of a motor vehicle. That is a misdemeanor punishable by up to 1 year in incarceration and a $750 fine plus court costs. You understand that?
Yes, I do.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right, 2 things about it. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. Hear me?
Yeah, I can hear everybody else.
Okay. You understand that it means that you're not willing or wanting to contest this charge.
Yes, I do.
All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, I do. Your Honor.
All right. Now understand, and the basis for the no contest plea.
Potential civil liability.
All right. Understanding all of that, do you still wish to plead no contest?
Yes, I do. Your Honor.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, I am.
All right. You signed an advice of rights form, is that correct? Any question regarding any of those rights? You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up, pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No.
to plea? Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes.
of your own free will? And because you believe that you are indeed guilty, or I won't ask you that, never mind. Court has been provided Ann Arbor Police Department report for their case number 25-17-355. Any objection to the court reviewing that report to form the factual basis?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt to the defense counsel. Have I complied with the court?
You have, Judge.
Yes, sir.
Court will accept the defendant's plea of no contest. 2 count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
June 6th at 10 a.m. with Judge Perry.
June 6, 2025, 10 a.m. before Judge Perry.
Thank you, Your Honor.
Thank you.
Would the court allow me to address Ms. Gregg's bond?
Sure, let's spend all day on this. Go ahead.
Sorry, Judge. Your Honor, her bond is currently 5,000 with a 10% provision. She's unable to post that bond. That bond was set in mind with this charge being a felony. She has now pled to a 1-year misdemeanor. She spent the last 50 days incarcerated. Should she be released, she does have stable housing that would be in Ypsilanti with a friend. She does also have employment lined up as well, should she be released. We would ask if the court would consider a personal bond. She's also been in touch with community mental health, and she will be working with them upon release.
Response.
Mental health, we would have an objection to the lowering of the bond. Since it's been reduced.
Okay, I will or bond to a $5,000 personal recognizance bond. Defendant, and with the condition to maintain contact and communication with community mental health. Okay,
Thank you very much, Judge.
you're good.
Oh, yeah,
All right. Follow through on everything.
I will.
You hear me?
Yes, I will.
All right,
Thank
thank
you.
you.
Thank you, Judge.
And that closes this intense session. From Washington's fiery bond battle to the quieter resolution of other defendants' cases, Judge Simpson showcased both firmness and patience. The key takeaway: courtroom order is non-negotiable. Defendants may bring passion, excuses, or even confrontation, but at the end of the day, the judge's decisions rest on credibility, consistency, and legal structure. Washington's outbursts didn't earn him freedom. They reinforced the perception of unpredictability. Meanwhile, other defendants demonstrated the smoother path: cooperation, clarity, and acknowledgement of the system's rules. This case teaches us that while emotions run hot, law runs cold and steady. If you found this breakdown as gripping as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Your voice matters here. What would you have done if you were in Washington's shoes?